everyone, and thank you for joining us for today's session, which is kindly sponsored by Northcote Beaton. Today, we will be looking at how to prepare for completion and practical examples of the steps you and your client can take to avoid any completion day nightmares. My name is Stephen Smith, and I'm delighted to be joined, as always, by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Good morning.
Morning.
Before I hand over to Ian, I'd just like to go over a few items so you know how to participate in today's event. You're listening in using your computer system by default. If you prefer to join over the phone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. The telephone is toll-free, so it's just local charges that would apply there, if any. You will have the opportunity to submit text questions to Ian by typing your questions in the questions pane of the control panel. You can send in questions at any time during the presentation, and we will collect these at the end and address them during a Q&A session at the end of today's presentation. You can also raise your hand during the presentation if you're having any difficulties with either the sound or other technical issues. We will be able to speak to you over the chat box feature and hopefully resolve any issues you may have. You can also email me directly if you do have any sort of sound or other issues. Finally, we've included the notes for today's session in the handout section of your control panel. Again, if you're having any issues accessing these notes, please let me know through the chat or Q&A section, or send me an email and we can get these sent over to you. Anyway, I'll now pass on to Ian for the main part of today's presentation. Thanks, Ian.
Thank you, Stephen, and good morning, everyone. First of all, a massive thank you for Stuart Title for organising today's event and to Northcote Beaton for sponsoring this event. It really is a delight to work with these organisations that provide great services to the legal profession generally, conveyancers in particular, but who also organise events such as this to enable me to share my very limited knowledge with regard to issues associated with conveyancing. So a massive thank you to both organisations for inviting me along today and to talk to you about issues, as Stephen mentions, relating to the preparation for completion and issues arising. The first thing to say is there are notes that accompany today's presentation. I'm not going to sort of trawl through the notes verbatim. They're there to support my presentation. If you'd like copies of the slides, they have been made available to Stuart Title and Northcote Beaton, and we can arrange for those slides to be provided. And I'm assuming that today is being recorded, so there will be a recording of this presentation available to you as well if need be. If you do need to contact Northcote Beaton, then the contact point is a lady called Katie Courtney. I've given her details on this slide. I'll also show her details on the final slide of the presentation. So again, you can make a note of that and contact Katie if you require any assistance with regard to product. The first thing I want to do is the thing I always do with regard to presentations such as this, and just to highlight and remind practitioners about some very useful websites. The Property Litigation Association website is a go-to site for my purposes in connection with providing advice and assistance to lawyers with regard to any problems that they may have with regard to residential conveyancing or commercial property transactions. It's a free to access site. You don't have to be a litigator to access it or indeed be a member to access it, but there's a wealth of material, particularly about problems associated with notices to complete, breach of contract, how to or what to advise clients in circumstances when the conveyancing process goes wrong and where completion is unable to take place for one reason or another. So again, it's a great site, it's free to access, there's case law, there's papers and opinions written on that site that will be useful if you're encountering problems. Which leads me to the first point that I want to labour this morning. We're transactional property lawyers, we're not litigators. In the good old days or the bad old days, it was possible, I suppose, to sort of assist or do some client hand-holding in the event of a dispute arising as a consequence of a transaction going wrong, just as it was possible to hold a client's hand with regard to application to first-tier tribunal or residential property tribunal or leasehold valuation tribunal as it was. I think those days are gone. Litigation is so risky, the costs vulnerability so high, the complexity of litigation so great that where you are advising clients about a delayed completion, about an abortive completion, I think it's important to have a property litigator alongside you to advise or assist in case litigation is necessary. If you don't have a property litigator in your litigation team, or you don't have litigators alongside you, then the practical tip is to talk to a local set of chambers who will have a chancery barrister, someone that specialises in property law issue. And in my limited experience, such barristers are often willing to provide ad hoc advice in connection with a set of circumstances rather than receiving formal instructions. So to talk through a potential problem and to discuss options or alternatives, I think is useful. The other point to note with regard to litigation and dealing with litigation is again a very practical point. It is absolutely essential that you ensure that when you are dealing with something that potentially could become contentious, that you make sure that you and your client are behaving reasonably. In other words, I've dealt with 3 or 4 sets of counsel recently who have told me that they've conducted litigation before the Court of Appeal and the Supreme Court, and they've been very fortunate in that the lawyer, the transactional lawyer at the very start of the transaction, when the problem blew up, and the client, when the problem blew up, were reasonable and sensible. Whereas I've seen cases where the other side has been cynical, disruptive, litigious, argumentative, uncooperative. And there's certainly no doubt in my mind that that initial sort of poor conduct with regard to a dispute has cost the client dear when the matter has been litigated. City of London Law Society Land Law Committee, useful, particularly for commercial property transactions. Also useful to see what's happening with regard to developments or changes in the law. RICS website, useful in connection with a code of practice for service charge in connection with residential leasehold transactions. Property protocols, useful for dealing with boundary issues in both freehold, leasehold, commercial and residential transactions. Leasehold Advisory Service, Association of Residential Managing Agents and the Legal Leasehold Knowledge Partnership, very useful for leasehold transactions. Again, we will touch on some problems relating to completion and leasehold transactions in a moment or two, but where we're wanting to challenge administration fees, fees for receipting notices of assignment or notice of charge, where we're wanting to dispute service charge provision, then the Leasehold Advisory Service has a wealth of guidance that can assist you and clients with regard to dealing with disputes. Finally, I mentioned the Legal Ombudsman site. Really useful for looking at what causes client complaints and client issues. And the main thing here is sort of endorsed and supported by what professional indemnity insurers are saying to me and have been saying to me for the last sort of 18 months or so. Most complaints, most negligence claims brought by clients relate to a failure to communicate effectively. So it's all well and good, as we'll be seeing in a moment or two, about serving a notice to complete on a defaulting party on completion day where they're unable or unwilling to complete. But first of all, we've got to make sure that we've got our client's authority to serve a notice to complete, and we've got to make sure that our client understands and appreciates the consequence of a notice to complete. The idea that we're giving the other side 10 working days to get their act together, and that during that period the other side can affect completion, and all that we'll be entitled to is actual loss or contractual interest, not both. So this issue about making sure that if something does go wrong as we are preparing for completion or at completion, it's important to not to forget the client and to explain to the client what's happening and to get authority and get instruction from the client before we proceed with a course of action. Frequently, I see conveyancers being annoyed with the other side, being concerned about the other side, and then serving notice to complete without having spoken to the client, without having explained to the client the consequences, or without having spoken to a litigator about whether or not it might be possible for some other form of action to be taken that might generate a far better result for our innocent client. Okay, so let's talk about preparing for completion and the role of the conveyancer. Done a lot of work recently, and both Robert and Stephen at Stuart Title have heard me speak recently about the issue of the retainer, making sure that we are explaining at the start of a transaction what we're going to do and what we're not going to do, make it quite clear the exact role that we're undertaking with regard to the conveyancing process. And explaining to the client the conveyancing process when we're onboarding the client. So, for example, with regard to that task, we've got to set realistic client expectation. Let me explain what I mean by that. A lot of firms, when they exchange contracts, will write to the client gleefully saying we've exchanged contracts today and completion is set for the 14th of February 2023. Well, is that actually correct? Is completion set? Can our client trust that completion will in fact take place on the 14th of February? Well, the answer to that question is no. Okay, the parties have contracted to complete on the 14th of February, having exchanged contracts today, but there's no guarantee that completion will in fact take place. So again, I think we need to set realistic expectations. Now, I know a firm and have done some training with a firm that have taken this to what I would class as an illogical extent. Because what they do is they exchange contracts on client's behalf, say that the parties are now contractually obliged to complete, and then produce a sheet, an information sheet to the client, explain to the client what can go wrong that can mean that completion can't take place. Well, I think that's going to generate nightmares for the client, questions for you, and is entirely unnecessary. But again, I do think it's important that we set realistic client expectation. It's also important, I think, when I'm setting the scene with regard to any training that I do, that we ascertain client objective. Why are we buying this property? Why are we selling this property? And that we make sure that our retainer, when we're onboarding the client, our report on title are all geared towards that aim or that goal or that objective. The last point I mentioned on the slide is important. It is important that we explain to clients the conveyancing process, the significance and consequence of exchange, the significance of and consequence of completion. Further, I think it's also important to explain to clients the fact that completion isn't the end of the transaction, and that we explain to a client when acting for a purchase about the additional tasks that are necessary after completion, SDLT returns, registration of title. And it's also important where we're taking out defective title insurance policies or other types of insurance policies that the client is made aware of their ongoing obligations to the insurer too. This issue about the duty to explain is important. You cannot simply provide clients with an information sheet about the conveyancing process. We've got to do more than that. We've got to provide an explanation. When contracts are exchanged, when we're gearing up towards completion, what is the significance and consequence of that? We'll look at some practical issues and some practical points relating to it before we finish today. What causes negligence claims? Now, this is where I get awfully negative, but I do a lot of work with professional indemnity insurers and do a lot of work looking at what causes negligence claims. And what causes negligence claims with regard to preparing for completion? Firstly, a failure to synchronize exchange on sale and purchase and to synchronize completion. Secondly, a failure to obtain completion monies in time, leading to a delay or leading to problems generating a notice to complete from the other side. It's absolutely essential with regard to preparing for completion that we build in time to make sure that everything is in order to complete. We also build in time to undertake file reviews, and we also build in time to be able to deal with something if something goes wrong. These days, the conveyancing process is very much a set process, and we're dealing regularly with transactions that proceed very smoothly, and as a consequence we get lulled into a false sense of security. I think we need, as far as our conveyancing processes are concerned, to have time to be able to deal with something that comes out of the ordinary or where something goes wrong. And therefore these issues that I mentioned on slide here are all issues that have led to negligence claims, but have led to negligence claims as a consequence of a firm or a conveyancer failing to sit back and just having a look or review of the file, which leads me to the sort of next point that I want to make. I would first of all, in any conveyancing file or case management system that I utilize with regard to residential conveyancing transactions, have an issues page. If I'm using a manual paper file, I will have an actual page in that file where I'm dealing with outstanding issues and referring to outstanding issues. If I've got a case management system, my case management system will have an issues page. And what I do when I'm reviewing the file, and I'd always review the file before I exchange and before I complete, is just check to see if there are any outstanding issues and to make sure that those outstanding issues are dealt with before the next stage in the process. The other thing that I think is important is to take time out to make sure that we've communicated to the client as to the stage we're at with regard to the conveyancing process and what happens next. So, for example, if we're exchanging contracts today, does our buyer client know that they're obliged to insure the property? Have they taken out an insurance policy? Once we've exchanged contracts and we're preparing for completion, are we going to tell our client about the significance of making sure that they inspect target property before we complete, particularly where that target property is empty or prone to vandalism, or where the seller has said that they're going to attend to something before completion to make sure that what has been said has actually been done. So those things are important, building in time. Negligence claims can arise with regard to mortgages. I'm just dealing with a horror story at the moment where a matter has been completed and a mortgage deed has not been executed, but executed by the buyer or borrower. And the buyer or borrower has gone to sort of periscope depth with regard to their solicitors and is not communicating. So we've got a lender who's lent money that's been utilised to acquire a property without a valid registered legal charge to secure that lending. Now, in that situation, just for clarification, the lender would have theoretically an equitable charge over the property, could secure that equitable charge with a notice, either agreed or unilateral, on the title, but the solicitor acting on behalf of the lender has failed in their duty to the lender with regard to securing a first legal charge over the property, with all the problems that ensues. The last point I make on slide contains key dates. Again, with management systems, again, with sort of manual processes, it's often the case that the final date to do something, so the last date of priority period, the last date with regard to the giving of notice, etc., is diarised. Well, I would maintain that that is a dangerous step, and I see lots of claims and lots of problems where we diarise the final date to do something, and on that final date, a problem arises, ill health, issues or problems with other files, etc., which means something is missed. Therefore, I think it's imperative that we diarise a week before completion, a week before exchange, and we undertake a review at that point, giving us time to be able to react where appropriate. Other issues that cause negligence claims on remortgages, redeeming second charges, failing to deal with boundary issues, failing to explain to clients the limitations associated with conveyancing and boundary sensitivity, failing to register leases, failing to deal with land registry requisitions, breaching undertakings can lead to negligence claims. So all of these things potentially have an impact with regard to preparing for completion. To avoid claims, there are some golden rules. One, do the simple things well. Use checklists. Use case management systems or diarisation, but don't diarise final date to do something. Give yourself time to react. In connection with dealing with undertakings, do think about a willingness to accept undertakings from the other side, and also contemplate the giving of undertakings in the conveyancing process. As we'll see in a moment or two, I have a number of golden rules with regard to undertaking that I think are golden rules for a reason, as we'll see. The first thing I want to talk about, and I mentioned in the notes, are issues associated with drafting transfers when we're acting for a buyer. A number of things here to explore and to discuss. First things first, in sending a transfer to our client to signature, do we explain to our client what the transfer is and what the transfer does? There is a school of thought that only the seller needs actually to execute a transfer in order for the title to be transferred to the buyer, and that theoretically is correct. However, where the buyer is entering into a deed of covenant, the buyer would be required to execute the transfer too. And there is a problem with regard to acting for co-owners and drafting transfers. And this is something that I think a lot of conveyancers overlook or don't realise, that the potential difficulty that can arise as a consequence of a failure to explain to co-owning clients what the transfer says with regard to co-ownership. So if you're sending a transfer out for the buyer client to execute, it is important that you highlight box 10 and highlight what the transfer states with regard to co-ownership. The reason I mention that is that I've seen 4 cases recently where buyer clients have not been aware or not had box 10 highlighted to them as to what the transfer is saying with regard to co-ownership, and what's being contained in box 10 is in fact inconsistent with client instruction or lawyer advice. So it's important to highlight what we're saying in box 10 and to explain to the client the significance of the fact you are buying as joint tenants in law and in equity, or tenants in common in equal shares or unequal shares. Reiterating what we've said in our report on title or in our advice to the client relating to co-ownership. The cases generate all sorts of interesting arguments about whether or not where the box 10 is defective and the buyer clients haven't signed the transfer, whether the sellers hold the property on some form of constructive trust for the buyers, and all manner of different arguments which haven't necessarily been resolved by the courts, but which show the potential problem. The other issue with regard to a transfer is I'd always indicate to the buyer what we've stated in the transfer with regard to addresses for service. And every opportunity in the conveyancing transaction, I would always remind the buyer client of the need to keep addresses for service up to date. In connection with transfers on sale of part, there are a number of important points. Firstly, the use of plans and the need for a plan to be Practice Guide 40 compliant. Secondly, the need for the description of the portion of land being acquired to be consistent with the plan, to make sure that the wording is clear, that the plan is clear, so that the boundaries to the site are clearly identifiable. If need be, using some form of boundary agreement or some form of determined boundary application to make sure there is a fix with regard to the location of the new boundary between the existing property and the new property that's being separately registered. The second point is to make sure that we consider easements and covenants. Easements that are being granted for the benefit of the property that is being sold, and significantly easements that are being reserved or retained for the benefit of the retained land. Dealing with a horror story at the moment where a solicitor acting on behalf of a buyer failed to ensure that the land that was being acquired had the appropriate rights relating to drainage, etc. And I dealt last year with a negligence claim where a seller's conveyancer failed to consider within the contract the need to retain rights over a driveway that was being sold as part of a development site. To that end, always have a look when you're drafting a contract on a sale of part with the TP1 form. Always have it on your desk, and which will remind you about issues such as the imposition or retention of easements, and also the imposition of restrictive covenants. Important point with regard to restrictive covenants, of course, where we're buying land that's burdened by covenant, we're going to tell our client about that burden. Where we're acting for a client who is buying land that has the benefit of a restrictive covenant, I think it's important that we tell the client about that restrictive covenant. But here's something again that's sometimes overlooked. Important to tell the client who has land that is benefiting from a restrictive covenant the fact that that benefit can be lost, either by application to tribunal under section 84 by the landowner who owns the land that's burdened by the covenant, or by inactivity by the owner of the land that benefits from the covenant. So where a client is aware that a planning application is being submitted, or where groundwork investigation is being undertaken by a neighbouring landowner, in the knowledge that the land that is burdened by a covenant, and in the knowledge that the landowner who is aware of all of this has the benefit of a covenant, it's important that that client is made aware of the need to react, and react swiftly. With regard to restrictive covenants, again, when we're drafting the transfer, we need to make sure that covenants are particularly well drafted and clear. Just been looking last night at a case that ended up in the Court of Appeal, where a lawyer was sued in negligence on the basis that he created a restrictive covenant that precluded development on land above a height above the roof line of an adjoining property. And the problem was that the site had been developed, and the property had been developed above the roof line but below the height of chimneys of the adjoining property. And the problem there is, well, what do we mean by roof line? Do we mean the actual line of the roof, or do we mean the maximum height of the property, which would include the chimneys? And again, there was some dispute as to what roof line actually meant. The important point there is it should be quite clear as to what a roof line is, or what the maximum height is, or what the constraints or requirements are with regard to windows or development, etc. Clear, precise wording, examples being provided as to what would or would not constitute compliance are certainly useful. As far as dealing with sales are concerned, if you're acting on behalf of a seller of land, you should always advise the client to consider the need to retain easements and also consider the imposition of restrictive covenants on the land that's being sold. Particularly these days, with a sort of bizarre planning regime and a risk that the planning regime may alter, relying on planning to control or prevent development has to an extent been dissipated by the relaxations relating to planning, meaning that the imposition of restrictive covenants and the enforcement of restrictive covenants becomes more and more significant. Let's talk about preparing for completion. I've already covered the issue of timing. The second thing I want to talk about are adverse entries with regard to searches. If you are doing an OS1 and the OS1 reveals adverse entries, the imposition of a notice, the imposition of a restriction, a priority period in favour of another search or anything of that nature, would that entitle the buyer to refuse to complete? Well, the answer is it depends. What you've got to do is look at what the adverse entry relates to, whether that adverse entry is capable of removal or challenge before completion or after completion. The important point with regard to searches, and it could relate to pre-exchange searches, pre-completion searches, that you're getting search results in and that you're able to react to those searches and give the seller time to deal with them where appropriate. Again, just recently, I've been looking at 3 or 4 different cases where sellers' solicitors have got themselves in an awful mess with regard to the buyer becoming aware, courtesy of a land registry search, of a recently imposed notice on a registered title. And the seller has, the seller's lawyer has immediately reacted to the imposition of a notice by giving an undertaking relating to its removal, on the basis of a false understanding or defective understanding that the seller will in fact be able to remove a unilateral notice or indeed an agreed notice. Now let me set the record straight. If you are undertaking a purchase, your OS1 reveals that an interested party claiming an interest in land has lodged a unilateral notice on a registered title. Unless that applicant is willing to cooperate with regard to its removal, there is no way in a million years that a seller's solicitors could undertake or given any form of undertaking to attend to its removal. The only thing that a seller's solicitor could do is challenge the notice. A challenge to a notice is not guaranteed to be successful and is not necessarily a swift course of action. So I repeat the point that where a unilateral notice has been lodged on a title, although theoretically it would be possible to challenge the notice, the reality will be that unless the applicant who lodged the notice in the first place is being cooperative, it will not be a quick fix to deal with its removal. And the seller's solicitor should not give any form of undertaking in that regard. Where the notice is placed on the title is an agreed notice, then again the same principle applies, and perhaps the position is even worse because of course an agreed notice can't be challenged. So only unless the applicant who placed the agreed notice on the title is going to be cooperative are you going to be able to, as a seller, be in a position to ensure that the notice is removed. Whether it's going to be removed in time for completion depends upon how much time you've got and how busy the land registry is. With regard to unregistered land, again, it's important to make sure land charges searches are dispatched and search results obtained. Be particularly careful with land charges searches to make sure you're searching against the correct name of the seller for the correct period of ownership. If in doubt, and there are a number of different names or variations of spelling, make sure that you search against each. Other searchers, do be alive to the fact that when we're preparing for completion, it might be necessary to renew or refresh our pre-exchange searches. Remember that a local land charge is an overriding interest, therefore it's binding on our client, whether our client is aware of it or not. Where there's been a long delay between exchange and completion, where our client becomes aware or we become aware that local land charges might have been registered against the property, or there was a change in circumstances with regard to inquiries of local authority, that could warrant the need for a new search before we complete. Just as an aside, where local land charges have migrated to the land registry, you are entitled to refresh an official search up to 6 times before you complete, as long as that refreshing takes place within a period of 6 months of the date of the official search. Unfortunately, only 50 local authorities have migrated their local land charges to the land registry, but that number will increase dramatically, I'm told, this year. So do think about refreshing searches, and make sure that when we are scoping our retainer, onboarding our client, explaining to our client the conveyancing process, the problems relating to searches. Of course, an official search will give us priority, will update official copies of the register, and will therefore assist us with regard to advising on title. But other searches have their limitations, and clients need to be aware of that fact. The next thing I've mentioned is execution of documents, and we'll talk about this in the notes. What about electronic signatures? There's quite a bit of guidance from the land registry about the use of electronic signatures. The point I would emphasize here is that it is really for the buyer to ensure, where the seller is signing a document electronically, that the appropriate platform is being used in connection with that signature. It is also possible to, where electronic signatures are being utilized, have to use counterpart documents where a wet signature is being provided by a buyer or a seller, or vice versa. And the other thing to do is to make sure that where we're using electronic signatures, the platform that we're using has been vetted, and there is a document trail with regard to that vetting. Final point with regard to the execution of documents, be it in electronic form or wet signature, absolutely essential for fairness to be aware of the risk of property fraud, and to understand and appreciate that property fraud is not something that we simply consider when we're onboarding clients, but we also consider risk and vulnerability throughout the transaction. Therefore, where I've got a document on my file, be it a transfer, a contract, or indeed anything else, I am under an obligation to check that signature against any other signatures that I'm holding on file in connection with the client. Next thing I want to talk about, because I am conscious of time, are undertakings. And of course, I refer to the case of Harker Sinclair and Your Lawyers Limited, which sort of highlights the potential danger of the provision of undertakings. The first point that I would make with regard to undertakings is that with volume and work and changes with regard to risk, the use of undertakings is sort of a given in the conveyancing process, obviously, but it generates risk. And the first question that I want to raise is, should you be telling a buyer client of the risk of relying on an undertaking from a seller in the conveyancing process? When we're providing information and explanation to clients, we should be highlighting areas of risk, whether that risk be seller identity fraud, whether it be advising clients that although we've exchanged, there's no guarantee that completion will take place. Or should we also be reporting to the client that during the conveyancing process, we're reliant on the seller providing undertakings that the seller's conveyancer honours, and the consequence of a failure to honour? Well, I think the point here is that if we're providing information and explanation to clients about the conveyancing process, it's important to explain to the client the use of undertakings. It might be prudent to advise the client with regard to risk, where we are buying a high value property and the seller's professional indemnity insurance is insufficient to cover any loss, assuming a breach of undertaking. You might want to think about warning a buyer client generally about the risk of breach of undertaking and the potential consequences of arising from it. If nothing else, the fact there's likely to be a delay pending registration of the title and obtaining a good and marketable title, where there is a problem with regard to discharging the seller's charge in the charges register due to a breach of undertaking. The other thing with regard to undertakings that I think is important is your firm's policy in the provision or giving of undertakings. And the golden rule here, I think, is that all fee earners are aware of a standard set of undertakings that have been agreed by your firm and that can be utilised as part of the conveyancing process. So you have an undertaking bank on your system that I, as a fee earner, can utilise. Undertakings that are provided on the hoof, undertakings that are provided by a fee earner in the heat of battle on the day of completion are notoriously risky and dangerous. Because remember, if an undertaking is vague or ambiguous, it will be construed against the person that has drafted it. And remember, something doesn't have to be called an undertaking to be an undertaking, and an undertaking to be enforceable doesn't necessarily have to be in writing. So undertakings are the cornerstone of the conveyancing process, are critical to completion, but do require a risk assessment. And again, where I'm dealing with a high value property, where I am dealing with someone other than a solicitor, it might be appropriate to warn my client of that vulnerability. The case law that I mentioned earlier highlights the fact that where an undertaking is provided by a solicitor, there is the additional protection that the solicitor's qualification provides, in the solicitor is an officer of the court, and therefore where there's a breach of undertaking, that breach will have consequences for anyone that is an officer of the court. So what are form of promise? What is said in the TA 13 will constitute an undertaking, and remember, undertakings given at completion, be it verbal or in writing, are equally binding. It is therefore important that we're specific about the wording of our undertakings. When we're redeeming mortgages, we're going to specify that we're redeeming a particular charge and referring to the date that that charge was executed, the date that that charge was registered, and the entry number in the charges register, so there can be no doubt that we are discharging the charge in favour of the Halifax Building Society that was dated the 4th of June 2021, that was registered on the 12th of June 2021, and is referred to as entry number 2 in the charges register. There can be no doubt as to what the undertaking relates to and what I am redeeming. Same issue relates to the production of documents. Remember, best endeavours and reasonable endeavours are two different things, and again, both have the potential to be vague or ambiguous. So if I'm undertaking to produce documents, what documents and what am I going to do to produce them and when? I've already explained the danger about undertakings to remove unilateral or agreed notices when acting for a seller. And I repeat the point that I need the cooperation of the applicant to lodge the notice on the title before I could give any form of undertaking at all. And any form of undertaking that I will have to be given cautiously and worded so that I'm not committing to a removal on the basis that if I'm challenging, if I'm cancelling, if I'm making application to the court, it could take me anything between 3 months and a year and a half before I'm going to get anywhere with regard to the removal of that notice. Again, important to understand that an undertaking is made on behalf of a fee earner or firm during the course of employment and during the conveyancing process. Any undertaking given in the conveyancing process will be deemed to be enforceable, and it is enforceable by someone who reasonably relies upon it. And again, in the conveyancing process, the usual form of undertaking would mean that it would be reasonable for the recipient to rely upon it. Problem areas, oral undertakings on the basis that who said what. So I wouldn't give oral undertaking, or if I did, I would immediately confirm it in writing. I repeat the basis of having an undertaking register or an undertaking library that the firm has agreed in the cold light of day is far better than giving undertakings on the hoof. Best endeavours and reasonable endeavours always require clarification, in my view. Undertakings should specify a time frame. Undertakings need to be recorded. Undertakings need to be recorded on file and in a register, and that register or the file needs to record when the undertaking is being complied with and is discharged. Keyword on this slide, precision. If you're providing an undertaking, it needs to be precise so there is clarity as to what is to be done to comply with that undertaking. Again, always explore the stance of the recipient. You know, is it reasonable for a recipient to accept an undertaking from you? Could there be vulnerability where you're acting on the sale of a house worth £15 million and you're carrying indemnity cover of £3 million? Remember that it's important to look at the circumstances, the matrix of facts sitting behind the undertaking, and remember that words aren't necessarily conclusive if they're vague or ambiguous. Lots of case law, Aldermore Bank and Kurt Steinheit Levy highlight the importance of undertakings in conveyancing transactions and confirm that in most circumstances any undertaking will in fact be enforceable. And Global Marine Drill Ships and William Labella, etc., highlight the fact that it's important for a recipient of an undertaking to undertake and investigate who's providing the undertaking and in what capacity. Again, with completion, where we've got a buyer wanting to go into occupation, where we've got a delay or a problem with regard to completion, it is so easy to utilize undertakings to try and resolve the issue on the basis that everything will be sorted out on the next working day or the following Monday. So pressure from clients can lead to fairness, providing undertakings to resolve the mess or the problem. But such an undertaking in such circumstances can come back and haunt the fairness. And therefore, again, I would be suggesting to inexperienced or junior members of staff that where they're in a situation where someone is asking for an undertaking to facilitate a buyer going into occupation, for example, that someone has a look at the file and does an assessment to determine whether or not that undertaking should be given. In other words, to consider the risk to the firm and to the client. I've given you this mention of Green Pine and Howard de Walden and Charles Russell Speechlys, which again highlights the fact that there is a distinction between a polite comment and an undertaking, but that's overridden by the point that most statements in conveyancing transactions will amount to undertakings. Remember that it might be necessary to seek clarification with regard to statements. So there's case law that highlights that the statement "we will complete on receipt of funds" is not in fact an undertaking. Golden rules then with regard to undertakings. If you're providing an undertaking, what are you intending to do? Is the undertaking going to be in writing? Are we going to rely on our undertaking library? If not, is our wording precise and carefully worded? Are we going to ask someone to assist or have a look at the undertaking before it's provided? We've got to clarify the capacity in which the undertaking is being provided, and we've got to monitor the undertaking when it's given and ensure that it's complied with within the timescales specified. Non-compliance, of course, will lead to contractual liability, will lead to risks of an action for specific performance against our client. Remember that specific performance is an equitable remedy and therefore not guaranteed. Remember that specific performance to be relied upon relies upon the person relying upon it to have clean hands. And of course, remember that a breach of undertaking will, in most circumstances, constitute professional misconduct. To protect yourself with regard to undertakings as we're proceeding towards completion or at completion, ask yourself, can the undertaking be complied with? Is it specifically clear? Ask yourself, who's providing the undertaking? Ask yourself, what's the vulnerability in connection with breach and how will that impact on client? Ask yourself, will it be enforceable? And ask yourself, can it be complied with? And again, be aware that clients need to understand where and how undertakings fit. If there is a breach of undertaking, the client needs to be aware of the circumstances and consequences. So Harkless Sinclair, which I mentioned a little earlier, the Supreme Court obiter highlighted the weakness of undertakings being provided by LLPs and incorporated entities that aren't solicitors. Also highlights the weakness of accepting an undertaking from someone that is not a solicitor. Does it really matter? Answer yes. What's the cautious approach? To let clients know about the potential dangers associated with undertakings that are provided in the conveyancing process, and to assess risk with regard to a willingness to accept undertakings from firms of conveyancers, and to appreciate risk with regard to the giving of undertakings. So, conclusions with regard to undertakings: consider discussing undertakings with clients. Raise issues with clients at the start of the instructions. Explain to clients as part of the conveyancing process the fact that undertakings will be provided, what the undertakings will do, and what the consequences are if an undertaking is breached. Make sure that you understand and appreciate that all clients are not the same. They will have different attitudes towards risk, different levels of understanding. So where we're providing explanation to clients, it's important that we challenge and question the client's levels of understanding with regard to the information provided. It's important that you review your undertaking exceptions processes in connection with transactions generally, and watch out for high-risk transactions. I repeat, a high-risk transaction where the undertaking relates to a sum of money being paid out or paid over that exceeds the firm's level of professional indemnity cover. And remember, CQS compliance issues have a policy with regard to undertakings. It is essential that all fee earners are aware of it and that the policy is adhered to. Don't know if any of you have had CQS assessments or visits, but one of the things a CQS assessor will do is not only check that you have a policy, but check that fee earners are aware of that policy, and significantly that fee earners are putting into practice that policy with regard to each and every file. The next thing I want to talk about are dealings with notices and restrictions as we prepare for completion. 2 points really with regard to notices to start with. Just because a notice is recorded in the charges register of registered land does not mean the interest in land is actually enforceable. Any notice in a registered title is simply a statement that someone contends that they have an interest in land, and that the land registry is accepted at face value, they have an interest. The registration of a notice in the charges register does not validate or legitimize an interest in land. Therefore, unilateral notices can be challenged or subject to cancellation, as can agreed notices. That cancellation process will normally be via the courts. But as I mentioned earlier, cancellation challenge is not going to be a swift and easy task. So if you are faced with a situation where a title has had a notice placed on it, it is important to understand it won't be a quick fix to seek its removal unless the applicant is being cooperative. Section 77 of the Land Registration Act 2002 can be a weapon to be used to persuade someone that's lodged a notice on a title to remove it. Because Section 77 says that if you place a notice on a registered title without reasonable cause, in other words, it's not reasonable to have placed it on the title, and someone sustains loss as a consequence, and any seller or buyer of a property would be someone that sustains loss if a notice is placed on a title on the basis that they're going to be liable for contractual interest as a consequence of an inability to complete. Such a person can recover that loss or claim that loss from the applicant who placed the notice on the title without reasonable cause. So agreed notices and unilateral notices are not guaranteed valid interest in land, but agreed and unilateral notices can be difficult to remove. Section 77 of the Land Registration Act 2002 may give you a weapon or an opportunity for dealing with their removal or ensuring that the applicant cooperates in connection with their removal. The next point I make with regard to restrictions and completion. Remember, a restriction on a registered title regulates or manages the registration of a disposition. It imposes a condition with regard to the registration process. It doesn't protect a disposition, but protects the registration of a disposition. A restriction has to protect an interest in land. A restriction must be capable of being complied with, and restrictions can be disapplied, cancelled, or modified on application. So where we're dealing with a title that's subject to a restriction, we've exchanged contracts and we're due to complete next week, and we find that the restriction can't be complied with, leasehold title and landlord's consent, third-party consent and third-party being uncooperative. If we have time, we may be able to disapply, cancel, or modify the restriction on application to the land registry. And here a health warning is required. There isn't a quick fix with regard to disapplication, cancellation, or modification of a restriction. So here we are on Thursday, due to complete next week, and there's a problem with regard to a restriction that can't be complied with. With the best will in the world, we're not going to be able to make an application to the land registry and have the restriction disapplied, cancelled, or modified in time to complete next week. Therefore, there are a number of points that I think are worthy of exploration. Point number one, when I'm a seller, when I'm auditing the title before I produce the contract bundle, I should look to assess if there are any restrictions on the title and assess whether or not those restrictions will be capable of compliance. Where I'm of the view they're not, where I'm of the view there's likely to be a sticking point or an issue, then I should consider at that juncture highlighting the problem to the buyer and contemplating an application to disapply, cancel, or modify at that point. If I'm acting for a buyer, again, I should assess the seller's title early on in the transaction, and again, assess whether, if there is a restriction, that restriction can be complied with, and probably contact the restrictioner at an early point just to assess what their stance or position will be, just to make sure that I can get the certificate or get the consent that I require to comply with the restriction in good time to enable it to be submitted, along with my application to register disposition. Section 77 of the Land Registration Act 2002 applies to restrictions just as much as it does to notices. So the principles that I made to you a little earlier apply to restrictions just as they would with notice. You've got to lodge a restriction with reasonable cause. And remember, a restriction can't blight a title. A restriction must always be capable of being complied with. Other things that I think are important with regard to preparing for completion. Once you've submitted a report on title to a buyer client, if you become aware of anything else that would impact on the client's decision to proceed to complete, you've got to advise the client of it. So if you become aware of an adverse entry in a search, if you become aware the seller having disclosed additional information, then it's necessary to amend the report on title and draw your buyer client's attention to the problem or issue that's identified, even though this is now being disclosed after exchange of contracts. The duty to advise clients continues at completion and afterwards. And again, where we've scoped the retainer at the start of the transaction, if we're doing work in addition to what is contained in the retainer during the conveyancing process, it is always worthwhile extending the scope of the retainer to incorporate the additional work that is being undertaken. Again, where a seller is disclosing an issue with regard to title after exchange, where the seller is disclosing something that would potentially constitute a misrepresentation that was made by the seller earlier in the transaction prior to exchange, consideration should be given as to whether or not litigation colleagues should be instructed to advise whether it is possible for the buyer to extract themselves from the contract, claiming rescission, etc., before completion on the basis of non-disclosure or on the basis of issues associated with title. Delayed completion. Important points here. Firstly, right, so we're acting for an innocent party. The other side can't complete. The seller can't provide vacant possession. The buyer's had his mortgage offer withdrawn, or the buyer's dependent sale is not proceeding. First point, find out what's gone wrong. Is this something that is simply a question of we're not going to be able to complete today, but we will be able to complete in the next 7 days? Or is this a fundamental failure of the transaction? Next thing, once we've got a position cleared as to what the position relating to the delay or problem with completion is, we speak to our client. We then need to explain to the client the rights and obligations. And if we're acting for a party that potentially is in default, it is always worth just having a review of the file to see if there's any potential defense or counterclaim that could be put forward in the event of litigation or a dispute becoming ongoing. Next thing, have a look at the standard conditions of sale and determine what is to happen with regard to a notice to complete. You can bring proceedings for specific performance without serving a notice to complete, but remember what I said earlier about specific performance being an equitable remedy and therefore not being automatically an entitlement for an innocent party to a breach of contract claim. Next thing, with regard to standard conditions of sale, we can serve a notice to complete, which makes time of the essence, but which gives the other side 10 working days to get their act together. We can claim contractual interest or actual loss that our client sustains where a notice to complete is served and the defaulting party completes within the 10-day time frame. It is important to understand that if there is a delayed completion and the delay is a simple mechanical issue that's capable of resolution, client should be advised of the availability of a notice to complete, but should perhaps be advised that such a step isn't necessary or appropriate in the circumstances. You should always advise the client of the availability of a notice to complete, but also explain to the client the advantages and disadvantages of doing so. These days, remember that although historically the best way of serving a notice to complete was via fax, fax is slowly but surely not available anymore, and therefore service should be by post or by email, assuming the contract permits it. Important to understand where there's a problem with regard to completion or where there isn't a problem with regard to completion. We should be constantly aware of the risk of property fraud, be it seller identity fraud, buyer mortgage fraud, etc. And the point that I made at the start of my presentation, that the issue of fraud is not just an issue when onboarding the client prevails. We talked about those issues. Should a notice to complete be served? It depends on all the circumstances, but your client, the innocent party, should be advised of the availability of a notice to complete. There is a case that held that a solicitor was negligent in failing to advise a client of the availability of a notice to complete, and therefore always explain to the client that it can be done, but to explain to the client the consequence. We're giving the other side 10 working days to get their act together. For a notice to complete to be valid, the party serving the notice to complete must be ready, willing, and able to complete at the time. A notice to complete makes time of the essence, gives the other side 10 working days to complete. A notice to complete theoretically cannot be extended, and theoretically the time for completion, the notice to complete cannot be withdrawn. As far as service of a notice to complete, there's now some confusion given the fact that fax is no longer available, and therefore either notice to complete is served via post, in which case deemed service is the day after the next working day, or service by email. If service by email is permitted, then the email is deemed to have been received on the next working day. Remember, the advantage of fax was that it was deemed to have been received 1 hour after it was sent. Once a notice to complete has expired, the defaulting party can be liable to a claim for breach of contract. The seller client, assuming the seller is the innocent party, can retain the deposit subject to a very important point. Section 49 of the Law Property Act 1925 gives the court a discretion as to what is to happen with regard to a deposit. There, for example, where a seller is able to sell elsewhere at a price greater than the original contracting price by the defaulting party, I have seen situations where a court has ordered that the deposit or part of it is returned to the defaulting buyer. This has particularly been the case where the buyer's default arises due to no fault of the buyer themselves, withdrawn mortgage offer or something of that nature. Completion issues and leases, just before we stop. Always check potential problems before exchange. Watch landlord's restrictions. Have a look at Practice Guide 19. There's a schedule to that now that highlights how to deal with landlord restrictions and problems with landlord's consents or certificates. With regard to notices of assignment and charge, the fee that the landlord charges is an administration fee and therefore is subject to a test of reasonableness. Fees for deeds of covenant are also administration fees that again are subject to the issue of reasonableness. So landlord's fees can be challenged, and I think that's under application to first tier tribunal under the Landlord and Tenant Act 1985. To finish, Stephen, we've scampered through lots and lots of issues. And what I would like to do now is just assess if there are any questions or queries that we can deal with. So I think, Stephen, over to you to see if there are any questions. While we're waiting for that, again, a massive thank you to Stuart Title for organising the administration with regard to today's event. A massive thank you to Northcote Beaton for inviting me along. Do be aware that Northcote Beaton have empty property household insurance that could be useful for conveyancers, distressed insurance and residential abortive transaction insurance. So there's a whole raft of potential products that Katie Court of Northcote Beaton can discuss with you that might be useful for you to support your residential conveyancing work. And of course, Northcote Beaton are agents of Stuart Title with regard to defective title insurance, and Stephen and Robert from Stuart Title and their colleagues are always willing to assist Katie and her colleagues or to assist you directly with regard to defective title insurance. So Stephen, over to you, and I hope there's lots of interesting questions.
Thank you, Ian. As Ian says, we're now going to begin answering questions from today's presentation. We are very short questions to be honest at the moment, Ian, so yeah. I will keep it open for 30 seconds or so just to see if anyone comes in. While we're waiting, if you're happy, Ian, as well, we'll run a quick poll just to keep everyone a bit engaged. So the question of the poll is, what do you see as the main danger for the property market in 2023? So I'll just launch that for people to answer there. The options are the lack of properties being marketed, the cost of living crisis, mortgage rates and availability, or land registry delays. So just keep that running for a moment.
Great. Thanks, Stephen. While we're waiting for the answers to that, Stephen, I was reading somewhere this morning that someone was saying that their view was that they thought that the pessimism with regard to the property market for the next 12 months was to an extent unfounded, on the basis that they thought that there would be a fall in property prices, but the fall in property prices would encourage buyers to buy, and the downturn in cost of living, etc., would compel sellers to be obliged to commit to sale, albeit at discounted prices. So it's quite an interesting article, really, basically saying, well, you know, what you've got is an adjustment in value that will actually mean the market will remain not as buoyant as it has been, but will remain moderately healthy. And I thought that was quite interesting. Anyway, Stephen, how are we getting on with our poll?
Yeah, no problem. I've left that open for a minute, so we'll share the results there. Again, we've run this poll once before, Ian, and I think quite similar. The main sort of things being the cost of living and the mortgage rates and availability. The lack of properties being marketed. I think that broadly goes along with what you were
Absolutely. Yeah,
as well.
it does. Yeah, really interesting, isn't it? Really interesting.
Absolutely. Well, it
Great.
is quite quiet on the questions front, so
All right.
we'll just close that off, and I think end the webinar
Okay.
there. Just as a reminder to
Yeah.
everyone, though, if you have any questions for Ian, for myself, or for Northcote Beaton following the webinar, then please do get in touch. Once you leave the webinar today, you will receive an automated email from GoToWebinar, and if you respond to this email, the replies will come directly to myself, and I can send any questions or feedback on to Ian or Katie. You will also receive a separate email from my colleague Robert Kelly, which will contain the slides and notes to today's session. But that just leaves me to say, on behalf of Stuart Title, Northcote Beaton, and Ian Quayle, thank you so much for joining us today, and have a great rest of your day. Thanks, Ian. Goodbye.
Thanks, Stephen. Bye-bye. Bye-bye.